Hello there.
Halo, halo.
Salam Indonesia, apa kabar?
Baik.
Apa kabar?
Okay. Today my body is in Malaysia, but my thoughts are with Miss Rizky and Miss Neneng because we are bringing you guys to Indonesia to learn how to protect and enforce your patent, trademarks, copyright, design, etc. IP, yeah, in Indonesia. So you are lucky to have two speakers today, Miss Neneng Sriwiyanti and Miss Rizky Dwi Amalia Pulongan with us. Both of them are from IP firm Pulongan Wilson and Partners in Jakarta. Yeah. So let me have a short introduction of both misses. So Miss Neneng, she's officially practicing before the Directorate General of Indonesia IP rights, yeah? And then she has more than 10 years of experience as certified IP consultant, as well as a member of Indonesian Advocates Association. So on the other hand, we have Miss Rizky as an Indonesian legal attorney and IP consultant at Pulongan Rizky and Partners. All right, let's welcome both of them. Hey.
Hello.
So today we're going to learn about practicing and prosecuting your IP in Indonesia. Indonesia has one of the, in fact, the largest market in Southeast Asia, right? It has, 280 million, almost 280 million population. That is about 40% of ASEAN's population. Yeah, so it's really, really huge market. So don't miss out to learn how to protect your IP in Indonesia. So I see Miss Neneng and Rizky, you are both beginning to work from home again, right? So in light of the COVID situation over there. So how is it? Is it really still serious? And what about the lockdown situation? Is there any updates from you guys?
At the moment, we are starting the lockdown 2.0 because the number of infected are not going down at the moment. So most offices are being sent home, back home to work from home. And consequences are being more tightened, enforced more if they find out that there's still offices opening more than the required quota.
I see. So what about the IP activities there? Is it like badly affected? Like, you know, I believe many places are experiencing decline, right, in the registrations there. And
Yes,
is the
of
court
course.
still ongoing? Yeah.
Well, from the business side, unfortunately, because of this COVID, so everything is kind of slowing down. But in practice, even though there are so many offices are closed and we are working from home, the process of application and registration, because of now we are in online system, so everything runs as usual, as scheduled.
As with many business owners, I have something really curious. If I were to file my trademark or patents in Indonesia, do you accept English or do I have to translate it? Or can I just file an English application? How does that go?
Well, from trademark specification of goods, you give us the specification in English, and then we are checking the specifications in accordance with the e-filing system, and then we are checking them, and if there is any discrepancy between what you propose and what is available, everything will be communicated to the trademark owner. And then as soon as we have your consent to go and you agree with the revised specification, if it's needed to be revised, and then it will be filed. So it will have to be in accordance with the e-filing system.
All right.
Specification of goods.
All right. So in the end, they still have to be translated into Indonesia language.
Yes. Yes.
All right, all right, all right. But as we can see, Indonesia is still quite advanced with the e-filing systems. So things can still be done online despite the work from home situation in Indonesia
Yes.
at large. Yeah, right. So
Yes.
let us begin with the interesting talk to be delivered by Miss Neneng and Miss Rizky for this morning. Yeah, let's welcome both of them. The floor is yours. You may share your
Okay,
screen.
thank you, Marcus. Share. All right. Can you see our PowerPoint here?
Yeah.
That's great. All right. Morning, everyone. I'm Rizky here, and with my colleague Neneng. I'm just gonna go right down to it and show you the key
All right.
topics for today.
Miss
First is
Rizky,
IP 101, which is
hold
what
on
is
for a moment. I will mute Miss Neneng for a
yes.
while you speak because there's an echo. There's an echo. So I will mute Miss Neneng while you speak, Rizky. And then when Miss Neneng speaks, you can unmute yourself. Yeah. All right.
That's great. Okay.
Yeah. Yeah. Carry on. Thank you.
All right. Okay, so as you can see here, this is the key topics that we'll be talking about. IPO map in Indonesia. First is what is IP, the 101 of it, the basic, and then how to obtain it, the rights, and how to enforce it. These are the key topics. All right, so IP 101 means the basic for people who don't know what IP is. So what is intellectual property? Intellectual property is the creation of the mind according to World Intellectual Property Organization. It is a product of human intellect, which law protects. Why protect? Because it is valuable. And in business, rights to these assets are considered, rights to these IP are considered as tangible assets. So this brings us to IP right? IP rights are exclusive rights given to the person who create or own the product of human intellect to benefit from their own creation by using it, commercializing it, or prevent others from using it. As you can see here, there are two categories of IP right. There's copyright and industrial right. You can see here what copyright covers and what industrial right covers. And industrial rights cover trademark, patent, industrial design, integrated circuit layout design, secret, and variety plan. Today we will be focusing on four most common IP aspects, that is copyright, trademark, patent, and industrial design. All right, so before we jump in, I'd like to show you an example of how different aspects of IP plays a role in a single product in a business realm. Yeah, you can see here BlackBerry is used as a trademark. And then there's the computer program being used within the phone, that's the copyright. And then there's the IC layout design within the phone. And there's industrial design, which is the appearance of the phone itself, like the color and everything. And then last, there's patent, which is the invention in the form of small computer, which can be put into your pocket. All right, so now I'm bringing you to the Indonesian realm. Here are the most updated laws which cover the protection of IP rights in Indonesia. You can see yourself, it's quite a lot there. And now I'm gonna give Ms. Neneng here the time to talk about copyright, trademark, and industrial design. If you can unmute yourself. And I will, Marcus, do you mind unmuting Neneng and can mute me right now, for now?
Yep. Done.
Okay, so we come to the roadmap of IP protection. We are talking about how to protect your IP. First, we come to copyright. And then this is what we are talking about. Copyright is basically ideas that have been realized into real form and declared. And it will be in declarative principle. It means that you don't need to have it registered, but as soon as you declare, you announce it, then the copyright is protected. Okay. And this is creation that are protected under the laws. There are books. The example is this. books, speeches, props, songs, drama, works of art, works of applied art, works of architecture. This is math, art, batik artwork, other motif, and basically everything that is protected under the copyright law. There are video games, computer programs, and this we are talking about moral rights and economic rights. So copyright comprises of moral rights and economic rights. Moral rights, it's inherently right to self-creator, as to commit economic rights is exclusive right to gain economic benefits for the copyright holders. And there are protection for the moral right is valid indefinitely, exception for C and D during the copyright term of the work. C and D is modify the creation according to the community decency and change the title and subtitle of the work. And this is economic rights protection for economic rights. So there are differences in protection for the economic rights for copyright. So we have to see each individual creation, what is the creation, and then we shall be able to determine the economic protection term for the each rights. And this is also applied art, the different time protection term from the applied art. And this is also related rights. Related rights also consisting of moral rights of performers, economic rights of performers, economic rights of phonogram producers, economic rights of broadcasting institution. And this is for recordation. As I mentioned earlier, that recordation or registration is not required, but the IP office provide a mechanism for you, applicant or copyright holders, to record their creation with the IP right office. And then we go to the trademark. This is the classification of mark. There are pictures, name, letters, numbers, logo, words, arrangement of colors, also sound and hologram, and combination on all of them. And it is the differentiate in goods and services. There are 45 classes in accordance with NIST classification, Indonesian follow international classification. And this is trademark protection. The system is constitutive system. It means that you have to register your mark in order to be registered, to be protected. Compared to the copyright, it is not registration but declaration, but the trademark protection is registration. And trademark protection follows first to file principle. And then protection period is 10 years since filing date, and it can be renewed every 10 years. And this is non-registrable trademarks. So in accordance with trademark law, there are signs or marks that cannot be registered, and this is the criteria. Among one of them is that public name or sign considered as public property, like symbol of skull for danger, like that. And also one of the examples is non-distinguishing features. It means that it's very simple, that it cannot differentiate your products from others, so it may not be granted as trademarks. And this is the procedure for you to file a trademark application. Start from filing, so formality examination, and then publication, and then substantive examination. And then if the mark application is granted, it will be registered for 10 years and can be renewed every 10 years. The timeline is around, in practice, it takes 2 to 3 years. And then this is Madrid Protocol, because of Indonesia is not a member of Madrid Protocol, so IP office also facilitates the registration of trademark, international trademark. And we go to industrial design. Industrial design is a creation of shape, configuration, compositions of lines. Practically the appeal of the products that is eye-catching and has aesthetic impression, you can protect it in industrial design system. And this is the requirement for registration. It has to be novel. Novel means it has not been disclosed anywhere else. And there is an exception of unless 6 months in national and international exhibition, education, research. That is the exclusion of the novelty requirement. And also there is a procedure for filing a design application. Start from filing, administrative examination, publication, and also examination. And there is also a time for any party who has objection, they can file an opposition, as well as in trademark also. And this is scope of protection for industrial design. basically making the rights exclusive to the design holder and to exempt people from using their design rights without authorization from the right holder. And the terms is 10 years computed from filing date, and it cannot be renewed, non-renewable. And now we go to patent. I will give the opportunity to Miss Rizky again. Maybe Mr. Marcus can change the audio so anybody can hear her. Thank you very much.
All right, thank you, Ms. Neneng. Unmute, right? Okay, I will be talking about patents here. So far we have discussed three matters, which is trademark, industrial design, and copyright. Now I'll be talking about patent. So what is patent exactly? It is basically an exclusive right, as mentioned earlier, granted by the states to inventor or owner of the patent for invention in field of technology for a specific period of time, and to prevent others from using without consent. And these rights are transferable. That means you can give it to someone else for the rights can be given to someone else.
We could still hear your echo. Can you adjust your mic a bit or something?
Hello? How is it? Still echoing?
There is still echo.
You can share a computer with me. How about now?
There's still a little bit.
Mute the mute. Oh. Atau enggak? Is it still?
Yep, it's better now.
Okay. Yeah. How are you gonna? I just put it there. Okay.
All right.
All right. So.
Sorry for the interruption. Yeah.
Sorry for the technical difficulties there.
Okay.
Anyway, so back to patent. So patent is an invention. It has to be for invention in field of technology. All right. So what is an invention here, right? What is the definition of invention? Well, invention is inventor's idea, which solves problem in the field of technology in the form of product, process, or improvement or of product or process. So what is not an invention? Here are the list. You can see aesthetic creation, because that falls under copyright. That doesn't solve any problem. And then schemes, method in conducting activities, mental activities, games, business, and then computer program. This is interesting here because previously computer program is not included as an invention at all, but then under the new law, computer program which have certain conditions like having characters, technical effects, and providing technical solution can be regarded as an invention. But then you have to keep in mind this is still a fresh understanding, and therefore the implementation might still be subjective to each examiner's point of view. Next is the presentation of information. Like this presentation is not an invention. Lastly is discovery. Discovery means basically anything that you find in nature and does not require further step to create. The new law defines discovery as new use of existing products. As maybe some of you know, Swiss type claim that was previously allowed in the old patent law, but not now. And then the second one is new form of existing compound, which does not have any significant improvement of efficacy and difference in the chemical structure. Now that one is not considered as invention anymore. Okay, next. So we know what is invention and what not. Now we have to know what can be patented under the Indonesian law. So maybe something can be considered as invention, but maybe it's not, but it still cannot be patented in Indonesia. These are the non-patentable subject matter. I'll give you an example of the first one, which is any process against rules, regulations, religious morality, public order. If anyone knows, it's battery-operated vibrator for sex toy. In the US, there is this product invention that's actually granted, but not here. Here, it cannot be patented religious morality. And then another example will be scientific theories and mathematical formulas. There's a crack theory by Mr. Habibie, our former president. It solved the problem, but cannot be patented in Indonesia because it is considered as scientific theories. And then living creatures is not allowed, like human plants, except for microorganisms such as amoeba, yeast, virus, bacteria. And then the last one is biological processes for reproduction of plants and animals. And example for this is in vitro fertilization. It's registered in the US, but not here. I mean, not allowed here. Okay, so when we're ready to file our invention, we need to know the scope of protection itself and to what extent does the law protect it. So first we need to understand the principle. Indonesia adopts application-based protection, which means that the rights are born from filing the application in the patent office, unlike copyright, which my partner has mentioned earlier. And then Indonesia adopts first to file principle, which means patent rights are given to those who file and obtain the patent rights first, not to the one who invent first. Next principle is territorial protection and universal examination, which means that protection is only given to within the country which the application is filed in. So you file in Indonesia, you only can enforce your rights in Indonesia. But despite this, the examination of requirement to fulfill the patentability, they will compare it with the world database, not only Indonesian database, to check if they fulfill the requirement to get the patent. So this requirement, what are those? What makes it patentable? There are three. First is novel, new, as Ms. Neneng mentioned earlier. That means no one has filed for the same invention as yours before this. And then it must have inventive step, how obvious and predictable your problem-solving invention is through the eyes of the experts in the field. Lastly, it must have industrial applicability, which means that the invention can be produced over and over again with the same quality. Okay, so in obtaining the rights, there are two types of application you can choose from. There are patent and simple patent. And simple patent, sometimes it's called as a utility model in other countries. So Indonesia is called simple patent. The difference actually heavily relies on the patentability requirement it needs to fulfill. While patent has three requirements of what I mentioned earlier, simple patent only needs two. An inventive step here is not required. You only need to prove the novelty and industrial applicability. And this also explains why the process to obtain simple patent takes shorter time, which brings us to the next difference here, which is that the patent will be granted for 20 years, while simple patent will be given protection for 10 years, which is half the time. And both of these period protection are non-extendable. So once your protection expires, it will become public domain and anyone can use it. Okay, so lastly, for patent, Indonesia accepts both PCT application and Paris Convention. And so what are these? These are two basically international application routes that you can take if you like to file in more than one country. Paris Convention allows you to file a patent in your own country first, and then you get a 12-month period after this filing date in the first country to file in another country, but still have the subsequent application to be regarded as if they have been filed on the same day as the first application. For PCT, the concept is quite similar as it provides you with priority rights as well, but the difference is that you file it with the International Bureau of WIPO and it gives you more time, which is 31 months. And you have some kind of like a streamlined documents for it. But also this is a bit more expensive. So Indonesia, as I mentioned earlier, accepts both Paris Convention and PCT application for patent, but only Paris Convention for simple patent. This is definitely something that you we want to keep in mind if you want to include Indonesia as your country consideration. All right, so this is the key prosecution event. I mentioned earlier the deadline. If you use Paris Convention or PCT, 12 months, 30 months. And then this is the requirement. I don't think I need to explain this. As we mentioned earlier, it has to be in Indonesian. You have to file in Indonesian for description and claims and everything. And then this is the procedure. Pretty much the same with trademarks. So you file, you get formality examination, check the documents, and then publication for 6 months for patent and 2 months for simple patent, and then you go to substantive examination, and then if your patent is deemed patentable, I mean invention is deemed patentable, then you will get granted a decision and you will get a certificate. Mind you though, the time that the law informs you is not really what is happening in real life, because in real time, for patent to obtain registration, it takes about 3 to 5 years, while for simple patent, it takes about 2 to 4 years. So that's something you need to know. Why? Should I put it on full screen so you can see the? Yeah. Yeah. Is that okay? It's all right, right? Okay. So next. Oh, wait. Okay. Okay. So yay, you get your patent. After you get your patent, what are you gonna do? Well, you have rights and obligations. Your rights is that, of course, you have exclusive rights to utilize and prevent others from using it without permission, and then you have the rights to commercialize it by license or by assignment. And with rights comes with obligations, of course. You need to pay for the renewal fee, and that's latest 6 months after grant and each year after. And lastly, you need to implement it. Well, this is quite interesting here because Indonesia oblige patent holders to make the product or use the process in Indonesia, but this might not be possible all the time. Consequences that if you don't do it, you can get invalidated. You can have someone request for invalidation, like a third party, for example, or you can have like, it's possible that you risk yourself to a compulsory license. So how's the solution here when you want to file it, but you can't? You just can't because of, business. Sometimes it's not easy to bring the whole invention. So solution is that you can request for postponement of patent implementation. And if you request for this, you have to do it 3 years, latest 3 years as from the date of grant, date of grant. And if you get it, it will be applicable for 5 years, and you can extend it as long as you need it, maybe even until your patent expires. And in the long term, there is omnibus bill being in talks, being a bill which would revoke Article 20, but then because of this whole pandemic, I'm not sure how long this would take to be accepted. So better not rely on that. All right, so I'm gonna give it back to Neneng again, so she could talk about enforcement these for IP matters. Marcus, thank you.
Okay. I know because of one of the idea of having your IP protected, it's how to enforce if there is any dispute. So we talk about enforcement routes. So there are civil lawsuit and criminal offense. So civil lawsuit is basically when you want to get your compensated for damage, we call it damages, and you can file it to the court. And then criminal offense is that when you are involving a police officer with regard to any dispute on your IP rights. And this is presenting on who can file the lawsuit. So this is basically the time frame is about approximately 6 months at first instance court, and it is under commercial court, under district court, and then if there is any further step, it can be filed through the Supreme Court through a cassation process. And this is about the regulation on the ground of enforcement. Copyright is against prevailing law and regulation, and there is trademark non-use for 3 years in a row, and then also mark that should not be granted for registration. And also you can also through well-known mark. So non-use, for cancellation against non-use, it is required to have a investigation by investigator and throughout Indonesia on about the use of the mark. And also the grounds for industrial design is not novel and also against the prevailing law and regulation, public order, religion, and morality. And also there is a grounds for the patent to be filed through like a cancellation or deletion, is that basically that the patent should not be granted for registration. And these are the reason, the grounds that can be taken to argue before the court of the law. And also again, the grounds is using IP rights without permission or rights. And the aim is claim for damages and stop all activities, production, distribution, and or trade related to the mark or any other IP rights. And this is about criminal offense. So lodge complaint to police investigator. And then there is also a mediation prior to submitting complaint except for piracy. And this is the criminal offense, and this is basically legal basis that you can use. Some of the provisions are presented here regarding copyrights. It's a violation against economic rights for commercial lease. And also this is against the economic rights. Legal basis grounds, some of the provisions they are presented here based on copyright law. And this is also a legal basis on violation according to trademark law. So basically having the mark, using the mark without rights that has any similarity with prior registered mark for the same kind of goods and or services, like that. So you may see here, the penalty can be imprisonment and or fine. So there are classifications on what can be imposed on alleged violation like this. And this is also industrial design. It's a criminal offense, and these are the provisions for the violations against industrial design rights. And again, you can see here there is imprisonment and fine, and or fine. So you might want to be more careful in the future with regard to the IP rights because it can be very serious. And this is also regarding patent, a legal basis as well. So this is criminal offense. So basically we are presenting here provisions in accordance with IP laws on any violations against IP rights. So these are the sources that we need to have. So basically that's pretty much about it from us. So I think maybe Rizky can add something about patent as well because
it's okay.
Okay, so basically this is the criminal offense and legal basis and everything, and the provisions is according with the law. So Rizky, do you want to add anything with regard to this patent for criminal offense, or because this is basically the provisions that can be used against any violations, particularly in patent side?
Yeah, I think Ms. Nana pretty much covered it. You can see that there's an exception though for patent for the violation. One is that if you import a pharmaceutical product protected by patent in Indonesia and you rightfully sold in another country, you don't get the violation. Or if you manufacture a pharmaceutical product which is protected by a patent in Indonesia within the 5 years before the patent expires for the purpose of getting a permit for selling the product, then that's considered, it doesn't fall under violation either because it's about pharmacy, medicines usually. That's pretty much about it. I hope that we cover the basic that you need to know. If you have further questions, please feel free to ask us questions here, or maybe if you have questions later, you can always contact us on our email on the last page.
Thank you very much,
questions?
Rizky and Neneng. Can you hold on to this slide, the slide earlier? Yeah. The slide earlier on the
Give me a sec.
pattern.
This one?
Yeah, this one. I notice in terms of pattern, comparison between pattern and simple pattern, yeah, not just in Indonesia, not just the protection period of simple pattern is half, the next slide, it's half of pattern, meaning pattern is protected for 20 years and then for simple pattern is protected for 10 years. In terms of violation, even the criminal charges, the fine is also half, right? For simple pattern compared to pattern. Yeah. So this is like pretty straightforward for pattern. Almost everything is like half of pattern, including the charges, right?
That's correct.
Yep. So any other questions from the floor, from the attendees?
Yeah. I mean, we didn't really cover too much into the details because of the time restraints, but feel free if anyone has any questions that they'd like to clarify.
All right. In Malaysia, we actually still practice the first to use basis for IP protection, meaning if you are not registered yet, but if you have actually used it, you can prove that you have used it and you can actually gain protection later on. So in Indonesia, is it really strict to, you know, adhere to the first to file thing? That means if you have not filed, but you have used it, does the IP office actually consider that?
Well, from the trademark side, I believe it's almost it's every IP realm here, IP aspects that the basis is first to file. So you need to have registration in order for your trademark, for example, be protected.
Okay. So meaning if you have actually used it earlier, you still can't argue much because you have not filed it, right?
Well, it's a matter of the sake of arguments in the court. But when you get to the dispute a stage, that means that everything has to be proven before the court of the law. But the first arguments that is very necessary for you to have is first to file.
Okay, so reminder to the audience out there, even if you have used your mark in Indonesia earlier, it's better to get it registered and file it there. So
Yes.
it will form more of a solid grounds in terms of argument. So I also see Indonesia now accepts hologram, sound mark, color arrangement. Yeah, so those are non-traditional mark. It's somewhat like Malaysia, since we've amended our trademark law, we have also accepted non-traditional marks. Yeah. So, and because Malaysia also acceded to the Madrid Protocol for international trademark filing. Yeah, so Indonesia also accepts international filing, right?
Yes.
Okay, nice. Rizky, just now you've mentioned under the new patent law amendment, Indonesia used to reject computer program, right? Now under patent law, the new patent law, somewhat computer program is accepted. So do you mean in this sense software applications?
Yes, computer program, basically any computer program that actually has a technical feature, then can be considered, I guess it includes software as well. But this is still very fresh, so I can't say much about the implementation because based on my experience, I had a computer program that we believe that it has technical features in it, but the examiner doesn't consider it as a technical feature, so it's still very subjective.
Okay, so has there been many applications on computer software being granted?
Not much that I know of, I guess. There's some that's being processed, but because the regulation's not really clear on it, it's not very precise yet. The examiner themselves are still quite reluctant to grant it. So, but then there are talks of regulations that would cover this computer program.
I see. I'm not quite sure about the landscape in Indonesia. What are the most granted or most filed field of technology there?
Say it again?
What is the most filed technology over there?
Most filed, you're talking about numbers.
Well, actually, it varies. You know, patent application is a varied. There are so many aspects of technology that can be filed, especially if you have the PCT application. So it means that the examination shall follow the result of the examination with the international examining authority. So it means that the examiner shall have more to see or more to consider when examining a patent application, like that. So the technologies are varies. What do you think?
Yeah, I cannot. If you're asking what is the most technology, if it's currently actually when we're talking about computer program, I think the reason why they're allowing certain conditions, computer program with certain conditions like having characters and technical effect,
All right.
development of Indonesia's business, digital business. So they're trying to expand it to that part by allowing this half of computer program. But if it's in terms of the whole patent, I can't really say. There's a lot of pharmacy, of course, the industry as well, mechanical. But if it's the most,
Okay, I see. So for Indonesia, the PCT entry deadline is 31 months, right?
yes,
Yeah.
instead of
So,
30.
so for people out there, if you have filed a PCT, International Patent Application, you have 31 months from your first country filing date to enter Indonesia, 31 months, yeah, bear in mind. Right. All right. Before we end the talk, we are coming to the end. Any other questions from the floor?
Before I like to add a
Last
little
question,
bit.
or do you have anything to add, our speaker?
Just a little bit. For this deadline, I think it's important because if you miss the deadline, you can, for PCT, you will get, maybe you can still file after deadline, but you will get charged quite an amount of money. And for Paris Convention, if you pass the deadline, you cannot follow the priority rights anymore. So I think this is important deadline for you to take note of.
All right. So you mean we have to adhere really strictly to the deadlines for Indonesia, right? So what is the penalty like if we are late to file in? Are we totally rejected, or we can still go in with a penalty? How?
As I mentioned earlier, if it's PCT, you can still go in, but you will be charged 5 million rupiah.
So is it really expensive?
5 million. Today, 1 year equals to almost 15,000 rupiah. So it's about, sorry, 1,000 USD.
$1,000
Yeah.
for late entry. Wow, that's a lot. That's a very huge sum for penalty. So for people out there, don't be late if you have
Yes.
enter.
Warning. Don't be.
Whether direct filing or PCT filing. So please stick to the deadline, yeah, or else you will either miss your novelty period, or you cannot file at all into the
Correct, yeah.
Indonesia, unless if you pay a lot.
You can still file, of course, to Indonesia, but the likelihood of you being rejected your own application in other countries are high because you don't have the priority rights anymore, right? If you file in Indonesia without priority rights. If that makes sense.
All right, understood. So yeah, thank you very much to Rizky and Neneng for delivering such interesting
Thank you,
topic.
Marcus, for inviting us.
Yeah, we have come to an end. So really thank you, and thank you to all the participants on Zoom and as well as Facebook Live.
Thank you.
All right. So
Thank you.
before we end our talk, yes. Okay. We have coming up. Let me share my screen.
Oh, okay. Logo.
All right. Okay, coming up. Oh, sorry, this is Chinese. Okay, we have, let me briefly introduce. We have NBS is in collaboration with a Chiku platform. Chiku platform is actually a directory for brands to actually list themselves and be searched on Chiku. Chiku is a fruit, right? A local fruit, tropical fruit. So the name is easy to remember. Chiku, you can go into chiku.my to check. So what it does here, Chiku is not just a lazy directory. They actually viral your brand on social media. So if you list your brand there, people can not only find your brand, your contact and your information on Chiku, they will also see it on the social media. So coming up, our legal advisor, Mr. Anthony Tay, will be delivering a talk. Okay, this will happen on the 29th of September. It's about branding. Okay, if you are in an F&B or service line, all right, instead of just registering your company on the SSM, it's not enough. So you will need to learn how to do your branding via trademark. So learn more with Mr. Anthony Tay at the end of this month, 29th of September, yeah? So any information can go on to our Facebook page. Coming up, we also have a mini MiniPTALK tour. This time we'll be bringing you to Thailand after Indonesia today. We're going to Thailand to look at the practices and problems with the design, trademark, and patent procedures, which will happen on the 9th of October, again a Friday, same time 11 a.m. Yeah, so you can register on bit.ly mini MiniPTALK Thai. All right, so we will be delivering this talk coming up. NBS is very active with its Zoom talk, so you can see 2 talks coming up. Yeah, real soon. All right, so any further information and inquiry, you can actually log on to www.facebook.com/nbsmy or our official website nbs.com.my to actually visit, inquire, and drop your message there. Right? Thank you very much and see you again. Thank you to our
Thank you,
speakers.
Marcus. Thank you, everyone.
Thank
Thank
you.
you.